The record reflects we are back in session. As far as the council are present, all members of our jury, our alternates are present. Our witnesses back on the witness stand, Mr. Jordan, and the process line.
Thank you. How much are you billing for your testimony here yesterday and today?
$175 an hour.
And is that the same rate for review of all the materials?
Yes.
And does that include travel time?
No.
Just
travel time is half that.
Okay, so half of 175 would be your travel time to court here.
Correct.
Okay. But the full amount is for your review of all the materials, correct?
Correct.
And writing your report, right?
Correct.
How much have you billed so far on this case?
So far, since 2015, it's 128 hours, which is $22,400, which is what I've been paid so far, so what I've billed.
How much have you billed?
I've billed the 128 hours.
Okay.
So I haven't billed anything since October, October of 2018.
Okay, so you haven't billed anything since last October, and since last October, you've done work on this case.
Yes.
And you prepared a report since October.
Yes.
So there will be more coming. How much since October?
In checking the notes on my phone, approximately 157 hours, not counting yesterday.
Okay. You retired from the Sheriff's Department after 30 years.
Correct.
And you, when you were asked what your occupation was, you said you were a forensic consultant.
Correct.
And you also sell prepaid legal services?
Correct. It's called Legal Shield now. It's a prepaid legal plan identity theft protection.
You haven't, you testified about your certification yesterday. You're not currently certified by the IAI, right?
Correct. The certification, I did not renew my certification, both for senior crime scene analyst and for bloodstain pattern examiner. And since it lapsed, and I'm not currently working in a full-time capacity, I would not be able to get certified with that agency.
And you haven't been certified in about 12 years, right?
Correct. From that organization.
Now, in order to get money, do you advertise your consulting services?
No.
Do you post what you do on your Facebook page?
I do.
Okay. And in fact, you posted some things about this case on March 14th, right?
I did not mention this case. I posted that I was doing a bloodstain pattern experiment where I built a 10-foot by 10-foot wall, or room rather.
Okay. Was there something about my question to ask you what the experiment was?
Objection argumentative.
I ask you allowed to complete his answer.
He's not answering the question.
You can re-ask your question.
Thank you. My question was, you posted something about this case on March 14th of this year, right?
Technically, no, since the experiment was not allowed in court, so I did not mention that. That's why I'm giving more
Objection,
detail.
non-responsive, move to strike.
Overruled.
The pictures you posted were involved in an experiment that you did for this case, right?
Correct.
Okay. So when I asked you, did you post something about this case on your Facebook page on March 14th, 2019, is your answer yes?
Yes.
And did you receive an email that I drafted requesting all of that material?
Objection relevant.
Sustained.
That night, on the same night, did you delete that post?
I did.
Did you delete that post because you were directed to?
No.
Did you receive, between the time you created the post and the time you deleted the post, did you receive an email that I had drafted?
I believe I did.
And after you received that email, you deleted the post?
Objection relevant.
Sustained.
So you will post about what you do on your Facebook page and you use hashtags, right?
Yes.
And hashtags are a way for people to search for certain things and come across your page, right?
Correct.
Objection, relevance, it's not a question.
Overruled.
And you post things like hashtag CSI humor.
Correct.
And in fact, you posted about a talk that you gave, I think it was last week, is that right?
Yes.
And the title of that talk was something along the lines of preparing for the Monday morning quarterback, right?
Correct.
And that's kind of what you do as a consultant, right?
You could think of it that way, yes.
Well, you think of it that way, right?
Objection, argumentative.
Overruled.
Yes, I do. I think everything is going to be scrutinized, just like whether you're prosecution or defense, everything gets looked at and evaluated for what could have been done.
Prior to your post about this case and you're taking down the post about this case, you hadn't written a report yet.
Objection, relevant.
Sustained.
Correct. I believe the time frame I had not.
There's no question.
Oh, I'm sorry.
That's okay.
Your report was drafted or dated March 25th, right?
Yes.
Okay. And that was actually the night before, or 2 nights before, you thought you were going to testify, or 2 days before, right?
I believe so, yes.
Okay. Because you posted on your Facebook that you were supposed to testify on the 27th.
I don't remember if I posted that or not. I could have, but I did not reference the case again.
Okay. But you were expecting to testify March 27th,
Objection, relevant.
right?
Overruled.
I believe so.
And your report wasn't drafted until March 25th, right?
Correct.
And you've been on this case for almost 4 years, right?
Correct.
How many times have you been interviewed by the defense's documentary team?
A couple. Not really. Well, I was part of an interview that he was doing. He didn't interview me per se individually.
Okay.
He was videotaping the attorneys, and I was there for at least 2 or 3, as I recall.
Okay. Did you bill for that time?
No.
Did you receive any compensation for that time?
No.
And that's good advertising, right?
Objection, argumentative.
It may be bad advertising. I don't know.
Overruled. You can answer.
That's hard to say.
Why'd you do it?
I didn't see a reason not to do it.
During your 30 years working for the San Bernardino County Sheriff's Department, you were taught to follow procedures, right?
Yes.
And in fact, it's important to follow procedures, especially with what you did and what you do, to maintain the integrity of the evidence in the investigation, right?
Correct.
And when you're following procedures, you're following certain processes, and one of those processes is documenting what you do as you do it, right?
Correct.
Okay, and that's how you were trained with the Sheriff's Department.
Correct.
And you tried to do that over your 30-year career with the Sheriff's Department, right?
Correct.
Because if the results of your investigation and your review point to guilt, that's important for the prosecution and the defense to know, right?
Correct.
And if the findings of your investigation or what you do is favorable for the defendant, that's important for the prosecutor and the defense to know as well, right?
I think my personal opinion is let everything out. Let everything in, if you will, personally. But obviously it doesn't happen that way because of objections and such on both sides.
Okay, that wasn't my question. My question was, is it favorable for the defendant? Prosecution wants to know that, and the defense wants to know that, right?
Objection, Mr. Relevant. And speculation.
The objection sustained is calling for speculation and conclusion is phrased.
One of those things, the documenting things as you do it, you've done a lot of work in this case.
Yes.
In fact, you've viewed a lot of the physical evidence in this case.
Correct.
You came to the Sheriff's Department, to the property room, evidence was pulled, and you were able to actually look at it with your eyes.
Objection goes beyond scope.
Overruled.
Correct.
You didn't document that, did you?
I did. I took photographs, which is documenting that.
You didn't write a report for that.
Correct.
Were you directed not to write a report for that?
I was told I did not need to write a report for that because they were not going to use that, what I did in that activity.
So you didn't prepare a report in that case, and that wouldn't be something that you would normally do in the sheriff's department, right? You
Objection,
would write a
relevant.
report.
Doesn't work for the sheriff's department.
I would, in sheriff's office, write a report on every single thing that I did. It would be a very basic report. On many occasions, I came, I took photographs, and that would be it. And then some reports, especially crime scene reconstruction or bloodstained pattern analysis, are definitely more detailed, and those are needed. But again, not always done in detail.
Did you, when you worked for the sheriff's department, write a report that you did something that you didn't actually do?
Objection, relevant.
Overruled.
A report that saying I did something that I did not actually do.
Yes.
Not that I have any recollection of, no.
Okay. In 2007, did you work a case with a suspect by the name of Robert Johnson?
Your Honor, can we approach?
Yes, counsel approach. All right, the last objection is sustained on both relevancy grounds and on relevance code 352.
Okay, you talked about one of your roles as a crime scene consultant or analyst is to look at a scene and look at what's missing.
Correct.
And you talked about what's missing in this case is potentially blood evidence, right?
That's part of what's missing, yes.
What else is missing?
I didn't see any damage to any walls or doors or the floor that could have been the result of a blow with the sledgehammer or any other kind of weapon. So I did not see that as well.
Anything else?
Objection, Peg.
Overruled.
Not that I can think of right now.
Okay. Can I have my computer? I don't know which one it is. Did you view these exhibits in preparation as you acted as a consultant in this case?
If those are from the interior of the McStay home, then yes.
You don't recognize them as being from the interior of the McStay home?
They appear to be.
Okay. Then why did you ask me if they
Objection argumentative.
There is an objection.
I'm sorry.
Objection argumentative.
Objection.
Argumentative.
Overruled.
In my experience, sometimes attorneys will ask questions in a sneaky way on both sides. And in this case, not knowing for sure, I like to make sure that if that is in fact the photo of McStay's home, that I would just qualify that as saying yes before I confirm that it is.
Okay. Well, I'll represent to you that I'm not being sneaky, and I'm asking you if those look like the pictures you reviewed as a consultant in this case of the McStay residence.
And I would object to the first commentary.
Overruled.
It does appear to be the photos I reviewed as part of this case.
And you also reviewed or looked at the evidence from the graves.
Yes.
Okay. Did you find any evidence in the graves that was consistent with things that would have come from this home or could have come from this home?
Yes.
Okay. Turning your attention to Exhibit 53, did you see what was recovered at the scene or at the graves, a bath mat?
Your Honor, I'd object is outside the scope.
Overruled.
We didn't go through what was in the grave that he analyzed.
Overruled.
I don't recall if material from the grave site would be something that would appear consistent or similar to that.
Okay.
Toilet seat cover.
Oh, I put up exhibit 293. Did you see that photograph before?
Yes, it looks familiar.
And that's a bath mat, right?
Looks like it is a bath mat or maybe a towel that would be on the floor.
Okay.
Yes.
So in exhibit 53, that would be missing, right? From the McStay home?
Objection assumes facts not in evidence that it was there.
Sustained.
That could be missing.
Objection
Right.
calls for speculation.
Sustained.
Did you see material from the gravesite that was consistent with towels?
I don't recall if it was consistent with towels.
Did you see material from the gravesites that was consistent with a bath mat?
I do not recall.
Did you see material from the graves that be consistent with a robe, a terry cloth robe?
I don't recall if it would be a robe or not. I'm aware that there was, I believe, a robe in the gravesite.
And just for the record, I've also displayed exhibits 297 and 293. Aside from exhibit 691 and exhibit 110, did you find any other evidence of any towels in the photographs that you reviewed from the McStay home?
I would prefer to look at overall photographs of the McStay home to see if there's any towels that are visible in any of the photographs.
You didn't do that in the last 4 years?
Objection argumentative.
Overruled.
Yes, I did. But
Did you? So my question was, did you see, other than what's depicted in exhibit 691 and exhibit 110, did you see any other towels?
To be accurate, I do not know if I saw towels or not. My focus for my testimony was not the towels within the McStay home, since there were thousands of photographs, I believe, and so I could certainly review that for you.
You've reviewed it, right?
Yes, I started reviewing these 4 years ago, so if you would like me to, I could certainly review the photographs.
And you billed for the time that you took to review those photographs, right?
Yes.
Should exhibit 279 there in the lower right-hand corner. Did you view that item of evidence from the graves?
That appears to be an item from the grave site, yes.
And is that a towel?
It appears that it could be a towel, yes.
I'll show you exhibits 48 and 83. Do you recognize those photographs?
Yes.
And exhibit 48 is a photograph of the kitchen island in the McStay home as taken by San Diego on February 19th.
Correct.
And exhibit 83 is a picture of the garage at the McStay residence as taken by the San Diego Sheriff's Department on February 19th.
Appears to be either the 15th or the 19th, yes.
Okay. Did you see exhibit 250, the left cup of the bra?
Yes.
Did you see the paint on the bra?
Wait, objection is to the photograph or the actual item, vague as worded.
Overruled.
It appears to be paint, and I did see that, yes.
And you saw that in person?
I believe I did, yes.
And you've seen that in photographs?
Correct.
Okay. And you see that the drip goes left. Let's see, is that the left cup? The drip goes sideways, it doesn't go up and down.
You're referring to the area here where...
Yes, sir.
Okay. Yes, it's a drip. I would kind of describe it more as a saturation, a gravity flow pattern.
Gravity flow meaning that it started to flow in that direction and it dried in place.
Correct.
And you're aware, because you've been on this case for almost 4 years, that the McStays were painting at the time.
Correct.
And you're also aware that in Exhibit 348, the paint that was on the sledgehammer is consistent with the paint that was on the bra.
Objection calls for conclusion and hearsay.
Overruled, you can answer whether or not he's aware of that being the case.
I know that the paint was analyzed. I don't have a recollection of the expert's opinion, whether it was consistent with or just could be that paint.
That wasn't important in your role as a crime scene consultant?
Objection argumentative.
Sustained.
Is that important in your role as a crime scene consultant? To know that information?
Overruled.
If I'm asked to have an opinion on that, then it would be important, yes.
And the fact that the paint matches, you don't remember what the results were, as you sit here
Objection
today.
assumes facts, not in evidence.
Sustained.
The fact that the paint on the hammer is consistent with the paint on the bra, you don't remember that as you sit here today.
Objection misstates the testimony, assumes facts, not in evidence.
Overruled.
I don't remember what the expert's opinion is, since it may be consistent with and maybe it's included as some paint that could be the same. I remember hearing the testimony, but again, I don't remember what her opinion is. I'm sure it's in her report.
Okay, you don't remember, right?
Correct.
Because it's not consistent with nothing happening in the home. Right.
Objection argumentative.
Sustained.
That could be consistent with something happening in the home, right?
Objection argumentative and speculation.
Overruled. Can answer if he has anything.
So specifically, something happening in the home related to someone with paint on their hands making contact with the sledgehammer?
Well, the fact that the same paint on a bra it matches the paint on the hammer.
Objection misstates the testimony.
Sustained.
That's what the FBI person testified to.
She did not. She never said it was a match, and I moved to strike counsel's
The
question.
objection sustained is closed.
My apologies. Okay. So let's say the hammer in Exhibit 348, the paint on the hammer and the paint on the bra are consistent with each other. And we know that the McStay family was painting at the time of their murder. That would all be consistent with something happening in the house, potentially, right?
Potentially, yes. Specifically, it's just that something with paint on it made contact with that area of the sledgehammer. It could have been anything with paint on it.
Okay.
It's a transfer pattern.
And the paint drying in place in a way would indicate that if the bra was on, she may have been laying on her side. Right?
Not knowing the orientation, it's possible, but I would want to look at the orientation of the bra and then make that opinion.
Well, you did that, right? You
No,
looked
it's
at the
not.
orientation of the bra. You saw it in person and you see it in a picture.
Objection argumentative.
Overruled.
Well, the orientation of the bra, that's not enough of an orientation to see where the strap connects to the bra and confirm if the bra would be, if that surface is even on the outside of the bra or the inside of the bra. The
Well, which
answer
is
is it may be, but again, I wouldn't have an opinion until I would really evaluate that bra and be able to see if it's on the inside or outside.
Were you told not to do that in this case?
No,
Did you do that in this case?
no.
Okay. Is the drip pattern that you see, the gravity drip pattern, consistent with her standing when the paint was applied to the bra?
Objection assumes facts, not in evidence that she was wearing it.
Overruled. Can answer if he has an opinion.
I would not want to make an opinion. To me, it would not be correct unless I looked at the bra to confirm the location of the bra or the flow pattern of paint as it relates to the location on the bra.
But you looked at the bra in person.
I did.
And her objection is argumentative.
Overruled.
So why didn't you make that determination?
Why didn't I?
Yeah.
I wasn't requested to do so.
Turn your exhibit to exhibit 360, turn your attention to exhibit 364. Did you view that item in person?
That could have been one of the items I viewed in person.
Okay. And when you viewed it, did you see what appeared to be blue tape or some kind of blue substance in there?
Objection, assumes facts not in evidence that he actually viewed it.
Overruled.
I'm not sure what item this is, number one. I can certainly see.
Okay, let's back up a little bit. You've been on this case for 4 years. You've viewed the evidence in person, and you're not sure what that is.
Objection argumentative.
Overruled.
And this is now badgering, Your Honor.
Overruled.
Correct, I'm not sure what that is.
Okay. Did you view anything that had what appeared to be blue tape in it?
Your Honor, can we approach now?
No, the objection's overruled.
This whole line of questions beyond our scope.
Overruled.
I do recall seeing some items that had what appeared to be blue painter's tape on it, yes.
And in the photographs, to the right there's exhibit 52. Did you see the blue painter's tape at the McStay home?
Yes.
Can I have my computer back? Did you view the left photograph there was marked as exhibit 7?
Your Honor, beyond the scope again.
Overruled.
I may have, I believe. I'm not 100% sure.
Did you view the items in exhibit 268?
Yes, I believe.
Does the paintbrush in exhibit 268 resemble the paintbrush being held in exhibit 7?
It does.
That would be something that could be missing from the McStay home, right?
Correct, could be.
Objection, argument, and speculation.
Overruled, the answer is no.
And did you view the backpack, the small backpack in exhibit 267?
Yes, I did.
Did you view any photographs of any children wearing that backpack? Or a backpack similar?
I may have.
If that's the same backpack, that could be something that's missing from the McStay home.
Objection,
Right.
calls for speculation.
Sustained.
Did you view exhibit 283?
I believe so.
Did you view that in person?
I may have, I'm not sure, I don't recall.
Did you view the photographs of that?
Yes.
Again, object outside the scope and relevance.
Overruled.
Did you view Exhibit 284?
Yes.
What is that?
That appears to be part of the, like the eyeball on whatever that robe, like a lion robe for an infant.
And is that consistent with the eye you see on the child, Joe Jr. in Exhibit 4?
It appears to be, yes.
And Exhibit 286, did you view that?
Yes, or at least photos, I believe, yes.
Is that consistent with the towel or robe, as you called it, in Exhibit 4?
It appears to be, yes.
And that could be something that's missing from the McStay home, right?
Correct.
Objection calls for speculation.
Sustained.
So when you were asked, when you're looking for something that's missing, you didn't mention those items that we just went through. Right.
Objection misstates his testimony. Well, and also goes beyond scope.
The objection sustained is mistaken in the testimony.
Well, you looked at photographs of the McStay residence, right?
Yes.
And you saw items in person and saw items from the grave, in this case, right?
Yes.
You didn't note the items that were in the grave that are consistent with what would have been in the McStay home.
Objection argumentative.
Overruled.
Did you?
I did not mention that in my testimony, no.
You didn't mention it in your report either.
Correct.
So we're clear, your final conclusion is there's no evidence of violence that would cause bloodshed in the home.
Correct.
You are aware that most of the in fact, all of the photographs that you relied upon were taken February 19th.
I believe some were taken February 15th from Deputy Tingley, I believe.
That's correct. I don't know if we saw any of those yesterday, but in any event, some were on the 15th and some were on the 19th, right?
Correct.
And the ones taken on February 19th, fair to say there's more of them, right?
Yes.
And those were taken after the house had been straightened up, right?
Correct.
The objection is too vague as to house.
Overruled.
Misstates the testimony.
Overruled.
Your conclusion assumes that the person who did this, or the person who did this along with someone else, or someone else didn't have adequate opportunity to clean up, right?
No, I'm not assuming that. I'm just making the observation that it did not appear that there was blood evidence in the house, and it certainly potentially could have been cleaned up, yes.
Okay, and along the lines of potentially being cleaned up, if there were long periods of time where a person of interest and their whereabouts were unaccounted for, that would be important.
Well, Your Honor, now that's argumentative. There's no facts and evidence for that.
Objection sustained.
Well, let me ask you this. Let's assume that the family was murdered the night of the 4th or the early morning hours of the 5th, February 5th. Okay. If a person between 7 a.m. and 10:15 was unaccounted for, that would be 3 hours and 15 minutes that they could potentially clean up, right?
Okay.
I would object as now the hypothetical is not, it's assumed fact, not the record.
Going for speculation and conclusion.
Well, how much time would be needed to clean up?
Objection calls for speculation. And vague as to clean up what?
Overruled.
So to clean up, if you could be more specific, clean up exactly what? Having 3 people, let's say,
Well,
with,
you tell me. There's no evidence of bloodshed. Let's assume.
Your Honor,
That-
if he allowed me to finish his answer.
Sustained.
Go ahead. Go ahead.
In my opinion, if 3 people or 4 were bludgeoned to death inside the McStay home, there would be blood spatter everywhere within whatever room they were killed in. And it would be really difficult, of course, nothing's impossible, but really difficult to clean up all of the blood spatter, not just what's spattered on walls and furniture, but what's spattered, or the pooling of blood also, that would have been either on the floor or the carpet. It would be a massive cleanup endeavor if that occurred as you asked me.
Can I get the overhead? Oh, can you? Never mind, can I get Mr. Himes? Okay, so a massive cleanup effort. You are aware that there, other than a diaper, there was no children's clothing found in the graves, right?
Objection assumes facts, not evidence.
I don't recall, but if there were children's clothing from the gravesite or not.
Isn't that important to determine if something happened in the house or not?
Objection argumentative.
It's not, as far as something happening in the house, I'm not sure I understand the importance of that.
Well, let me show you exhibit number, what is this? 109. 109. Did you view that photograph? Can you zoom in? Close.
Yes, I did.
Okay. What's on the floor there?
Clothing.
What kind of clothing?
Looks like potentially children's clothing.
And what's directly across to the right, if you zoom out, it's directly across from there?
A closet.
A bathtub? Directly to the right of the clothing? Off camera?
Objection calls for speculation.
Did you review the diagrams in this case of the home?
I did.
Okay. On the master bathroom, is there a bathtub directly across from the sink?
I can review that diagram if you like.
Please. If I can see what you're looking at.
So I'm looking at what is marked.
That's the first floor. This is on the second floor.
Okay, I don't have the second floor diagram pulled up.
Okay. Well, if I tell you that there's a bathtub directly across from the clothing, does missing clothing have any import to you as a crime scene consultant?
One, Your Honor, objection as to this, while counsel's testifying, it assumes facts, not evidence. And 2, this is all now speculation and beyond the scope.
Okay, so here's the exhibit. We'll get a number here in a second. You recognize that?
That appears to be the diagram of the second floor of the McStay home.
Okay. And do you see what's represented here as sinks? 2 of them?
I do.
Okay. And then directly up above the words master bathroom, that's a bathtub being represented.
Correct.
Okay. So you're aware that other than a diaper, at least you think, other than a diaper, there's no other children's clothing found in the graves.
Objection assumes facts, not evidence.
Right?
That certainly may be the case.
Okay.
And objection speculation is the answer.
And there was children's clothing here, which would be under master bathroom on this diagram, which is exhibit. We'll get it. There was children's clothing there, right?
Appear to be children's clothing on the floor of the master bathroom.
Okay. Would cleanup of killing children in a bathtub be easier than on a carpet?
Your Honor, now this is argumentative. This is closing argument of a made-up story without evidence.
Objection
Now-
sustained, assuming facts, not evidence.
And I would like to approach on all this.
Denied.
Well, you talked about it would be very difficult to clean up, right?
Correct.
Would it be easier if the victim was in a bathtub?
Objection assumes facts not in evidence.
It's an opinion.
Exhibit 19 was the diagram.
Exhibit 19 was the diagram of the second floor for the record.
Which one?
19.
So, I'm sorry, your question is easier to,
Clean up if the victim's in a bathtub.
as opposed to in the family room?
Yeah.
Yes, it would.
Yeah, and this is also display exhibit number
115.
115. That's a close-up of the, which you identify as possibly children's clothing there in the master bathroom, is that right? 115?
Correct. Several of the items appear to be children's clothing. I'm not sure what the black colored larger item is. That might be an adult.
Okay. You're also aware that there was no shirt found that was associated with Summer McStay in the graves, right?
Correct.
Okay. Your testimony yesterday involved a reddish substance on the dining room table. And your testimony, I think, is that's definitely not blood.
In my opinion, it does not appear to be blood.
You testified yesterday that it would not be proper to testify that something was blood from a photograph unless it had been tested.
I'm not sure if I worded that exactly in that way or not.
Would you agree with that statement?
I would agree with the statement that something could appear to be blood, and without confirmation of a test, I could not testify that it in fact was blood.
Is it your testimony that you've never testified that something was blood based on a photograph with no confirmatory test?
I would say that my opinion and that testimony, whatever you're referencing, would be that it was, in my opinion, it was consistent with blood. But I can't imagine that I testified that something was absolutely blood without a report.
Without a report confirming that it was actually blood.
Correct.
What's next in order?
2013.
Last February, did you testify in a case of the People versus Alfonso Garcia?
Yes,
And
I believe it was February, but on that case,
approximately February? I'm sorry, what's next in order?
2013.
I'm going to show you exhibit number 2013. We'll mark it later. Was that one of the exhibits you were shown in that case?
potentially yes. I see 3 placards. The Garcia case involved what appeared to be blood on a grass area. So if I can trust you that this is in fact, okay, from the Garcia case, then I will say yes.
And you testified that that was blood around those placards.
I would testify that that appeared to be blood, most likely is what I would say.
Oh, okay.
So if you have a transcript, we could certainly review that.
Well, let's certainly do that. Well, no, this one here. Okay, review whatever you'd like through here, and this is regarding Exhibit 100 here, where it says we're looking at placard 12, several placards. You can even go to the first page there. Let me know when your recollection's refreshed.
Okay, this, on page, that's marked 822, I guess this is not an exhibit, it's referencing blood that I refer to as blood-stained grass. I refer to on a cartridge, but this is not a close-up of that, and I don't appear that that's even visible blood. So maybe there's a different reference for a photo related to this part of my testimony.
Do you see anywhere in that testimony where you say appeared to be blood or consistent with blood?
What I see is I make reference that that has blood stains on the cartridge, and I may have previously referenced that my making reference to blood is the understanding that it may or may not have been tested, like I did even for the record doing the demonstration. When I referenced as blood for the demonstration, I said, just to qualify it, it's fake blood, it's not real blood, just for the record. Now, I may have done that here in part of this testimony prior to these questions being asked. I don't recall without reviewing my entire testimony on the Garcia case. But as it turned out, on this case, there were 3 people shot and were bleeding. So it was obvious blood was everywhere in this yard. So it was different than other scenarios where you might have a stain and really have no idea if it's blood or not.
Okay, so when I asked you, have you ever testified that something was blood without a confirmatory test? And you said no, your answer is maybe I did, maybe I didn't, I'm not sure.
Objection
Well-
argumentative.
My answer is I may have referenced and put a disclaimer in that testimony, since if it wasn't tested, and I don't recall if the DNA, I don't believe it was tested in the Garcia case. I don't think anything was done related to DNA. So
The prosecutor on that case was Mr. Crocker, right?
I believe so.
So again, my question is, when I asked you if you've ever testified that something was blood without a confirmatory test, you don't know.
In this case, I don't know if I had a disclaimer or not. So it's kind of how you could say, yes, I've testified of something that maybe wasn't confirmed, but either what I would normally do is to say, well, by the way, if it's not tested, maybe it wasn't blood. So that could be in this case. I've had other cases in that similar situations that I've testified that I've seen blood thousands of times. In one particular case in Idaho, I testified on a murder, and that was a big issue in court, whether I was an expert or not to even identify something as being possible blood. And so they did a hearing about that, and I was determined that I'd seen it thousands of times, so I could make that assumption that it appeared to be blood. If that helps clarify.
Not at all, but
Objection
let's press
argumentative.
forward.
Objection argumentative.
Let's press forward. I guess that was a long way of saying you may have.
Objection,
Objection
argumentative.
as commentary.
That's a question.
Sustained.
Is that a long way of saying you may have?
My wife would say yes.
Okay.
She would. She says I explain things too much.
You were here for Detective DeGaule's testimony, right?
Some of it, yes.
Just some of it?
Oh, I'm sorry, DeGaulle, San Diego?
Yes.
Yes, I was.
Did he ever testify that it was definitely blood?
No, I believe he qualified that he did not know.
Correct. Didn't he say it could be, but he doesn't know?
I believe so, yes, that's what he said.
And you were here for Dennis Williams' testimony, right?
Yes,
And she said the exact same thing, right?
yes.
And they said if they had seen it, they would have tested it.
I believe they said that, yes.
And that would be an appropriate response, right?
Yes,
Okay. And you were here for the cross-exam of both of those individuals, right?
correct.
And other than what was on the table, no one ever said there was blood in the house, right?
Talking about San Diego,
Anybody.
I think there was evidence collected by San Bernardino several years later, and they collected items that they thought were possibly blood after their examination.
Okay. And some of that blood came back to the current homeowners.
Correct.
Objection, Ms. Stacy's testimony is only one item.
Who rules on this one?
I guess my question is, during the testimony that you saw of Detective Dugall and Dennis Williams, they never said there was obvious blood in the house, right?
I don't recall them testifying to that, no.
They didn't say anything about cast-off patterns, transfer, anything like that, right?
Correct.
You spent 45 minutes doing a demonstration of blood spatter yesterday, right?
Yes,
Good for TV?
Objection,
Objection, Your
argumentative.
Honor.
Sustained is argumentative.
Is it, did you do that because it's good for the documentary?
Objection, Your Honor.
Sustained is argumentative.
So, after 4 years of being on this case, you limited your report to really one issue, and that is the stains on the family room table.
no, I don't believe that's,
Objection, relevance within his report.
Objection sustained is misstates the evidence.
And you showed us some exhibits. And I'll put up on the overhead if I can have the overhead. Exhibit 1078. And you labeled various circles there, and you described those yesterday during your testimony, right?
yes,
And Exhibit 1076 doesn't have any circles on it.
correct.
Okay. So you were able to, let's see, auto freeze. Oops. 2, you were able to, from this photograph, circle 7 points.
A through G, yes.
And you showed us exhibits. Let's see if we can get there. One 1075. Right?
Yes.
Did you show in your report or anywhere exhibit 40?
In my report.
Anywhere.
What is Exhibit 40?
I'll put it up here in just a second. If I can have my computer.
Do not object with relevance to what's in his report.
Overruled.
Oops. Huh? This might be a good time to take a break, Your Honor. I don't know if you
All
want to.
right, we'll take our morning recess this time, 15 minutes. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case. We'll see everyone back in about 15 minutes.